The Senate will come back to order. Committee reports.
April 19, 2023, the Committee on Health and Human Services, after consideration on the merits, the committee recommends the following. Senate Bill 284 be referred to the Committee of the Whole with favorable recommendation. House Bill 1026 be amended as follows, and as so amended, be referred to the Committee of the Whole with favorable recommendation. House Bill 1225 be amended as follows, and as so amended, be referred to the Committee of the Whole with favorable recommendation. April 19, 2023, the Committee on Agriculture and Natural Resources, after consideration on the merits, the committee recommends the following. Senate Bill 285 be amended as follows, and as so amended, be referred to the Committee on Appropriations with favorable recommendation. April 19, 2023, the Committee on Transportation and Energy, after consideration on the merits, the committee recommends the following. House Bill 1217 be referred to the Committee of the Whole with favorable recommendation, with a recommendation to be placed on the consent calendar. House Bill 1234 be referred favorably to the Committee on Appropriations. House Bill 1233 be referred to the Committee of the Whole with favorable recommendation. April 18, 2023, the Committee on Local Government and Housing, after consideration on the merits, the committee recommends the following. Senate Bill 213 be amended as follows, and as so amended, be referred to the Committee on Appropriations with favorable recommendation. April 19, 2023, the Committee on Judiciary, after consideration on the merits, the committee recommends the following. Senate Bill 282 be referred to the Committee of the Whole with favorable recommendation.
Introduction of bills.
Senate Bill 294, Senators Zenzinger and Kirkmeyer, Representatives Byrd and Buckenfeld, concerning increases in the amount of transfers from the General Fund to the Capital Construction Fund to be made on July 1st, 2023.
Appropriations.
House Bill 1136, Representatives Ortiz and Hartsock, Senators Winter F. and Liston, concerning health insurance coverage for a prosthetic device necessary for a covered person to engage in certain types of activities and in connection therewith making an appropriation.
Health and Human Services.
House Bill 1162, Representatives Woodrow, Senator Rodriguez, concerning the regulation of consumer legal funding transactions and in connection therewith authorizing the administrator of the Uniform Consumer Credit Code to adopt rules regulating creditor-imposed charges for certain consumer credit transactions that are secured by a consumer's potential proceeds from a settlement or judgment obtained in an associated legal claim.
Business, Labor, and Technology.
House Bill 1209, Representatives Bazinacre and McCormick, Senator Huckas Lewis, concerning the analysis of a universal health care system and in connection therewith making an appropriation.
Health and Human Services.
House Bill 1215, Representatives Sirota and Bazinacre, Senators Mullica and Cutter, concerning limitations on hospital facility fees and in connection therewith making an appropriation.
Health and Human Services.
House Bill 1218, Representatives Brown and Titone, Senator Huckas Lewis, concerning requiring that a healthcare facility inform patients as part of the informed consent process of services that the healthcare facility refuses to provide to patients when the refusal is for non-medical reasons and in connection therewith making an appropriation.
Health and Human Services.
House Bill 1237, Representative Belasco, Senators Will and Exum, concerning inclusive language access in local emergency situations and in connection therewith making an appropriation.
State Veterans and Military Affairs. Mr. Majority Leader.
Thank you, Mr. President. I move a call of the Senate. Hands, please.
Call of the Senate has been moved and properly sustained. Will the sergeants please close the doors and find those stinking senators and bring them back?
Senators Baisley, Bridges, Buckner, Coleman, Cutter, Danielson, Exum, Fields, Gardner, Janal, Gonzalez, Hanson, Huckas Lewis, Kirkmeyer, Kolker, Liston, Lundeen, Marchman, Moreno, Mullica, Pelton B, Pelton R, Priola, Rich, Roberts, Rodriguez, Simpson, Smallwood. Sullivan. Van Winkle. Will. Winter. Winter. Zenzinger. Baisley. Bridges. Coleman. Gardner. Mullica. Zenzinger. Baisley.
Majority Leader Moreno.
Thank you, Mr. President. I move the call be raised.
Motion is to raise the call. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the call is raised. General orders, second reading of bills. Senator Coleman.
Thank you, Mr. President. I move the Senate resolve itself to Committee of the Whole for consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it, and the motion is adopted. The Senate will resolve itself to the Committee of the Whole for the consideration of the general orders, second reading of bills, and Senator Coleman will take the chair.
Committee will come to order, and the court rule is relaxed for everybody up in here. Majority Leader Moreno.
Thank you, Mr. Chair. I move the committee proceed out of order for consideration of Senate Bill 172.
The motion is to proceed out of order to hear Senate Bill 172. All those in favor say aye. Aye. Opposed, no. The ayes have it, and we will proceed out of order to hear Senate Bill 172. Will the clerk please read the title, too? Senate Bill 172.
Senate Bill 172, Senators Winter, F. and Gonzalez, Representatives Weisman and Bacon, concerning protections for Colorado workers against discriminatory employment practices.
Senator Gonzalez.
Thank you, Mr. Chair. We move Senate Bill 172 on second reading, along with the Judiciary Committee report and Appropriations Committee report.
To the Judiciary Committee report, Senator Gonzalez.
Thank you, Mr. Chair. During the Judiciary Committee, we made a number of amendments in response to stakeholder feedback, and we move the report.
The motion is adoption of the Judiciary Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes surprisingly have it, and the Judiciary Committee report is adopted. To the Appropriations Committee report, Senator Gonzalez.
Thank you, Mr. Chair. During the Appropriations Committee appropriately appropriated the appropriations, and we ask for an aye vote.
That's an appropriate motion. The motion is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the Appropriations Committee report is adopted. There's an amendment of the desk. Will the clerk please read L18?
Amendment L018 by
Senator Winter.
Thank you, Mr. Chair. I move L018.
Proper motion. Please tell us about L018, Senator Winter.
This removes the oral complaint from affirmative defense and adds them to the record-keeping requirements section in 408. This is in response to a higher education request. It also allows for record-keeping of anonymous complaints. This was a request from C3, and it adds U.S. Constitution core language, which makes sure that you can't just quora all these complaints when we're talking about local governments. And this was a request from higher education at Adams County. I think this is a benefit to the bill, and I ask for a yes vote.
Seeing no further discussion, the motion is the adoption of L18. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. There's only one no vote, but the ayes have it, and L18 is adopted. There's a member of the desk. Will the clerk please read L19?
Amendment
Senator
L019.
Winter.
Thank you, Mr. Chair. I move L019.
To L019. Senator Winter.
It adds failure to promote to existing CADA language regarding marital status. It also fixes affirmative defense inconsistently with federal case law. And it removes availability for injunctive relief for violations of NDA provisions. And I encourage yes vote.
Seeing no further discussion, the motion is the adoption of L19. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. L19 is adopted. There is an amendment at the desk. Will the clerk please read L20?
Amendment L020.
Senator Winter.
Thank you. I move L020.
To L020. Senator Winter.
Thank you, Mr. Chair. This amends the Judiciary Committee report. It broadens the availability of the affirmative defense if, in response to a complaint, an employer takes action to investigate or address the complaint. So we think that this is a beneficial part of the affirmative defense, and we ask for an aye vote.
Seeing no further discussion, the motion is the adoption of L020. All those in favor say aye.
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 Opposed, no. The ayes have it, and L020 is adopted. There's a member of the desk. Will the clerk please read L028?
Amendment L028.
Senator Winter.
Thank you, Mr. Chair. L028 corrects a typo that was in a previous amendment. I move L028.
That's a proper motion and explanation. Seeing no further discussion, the motion, there is discussion on L028. Senator Gardner.
Yes, thank you, Mr. Chair. Well, it does look like that L028 is in order because what we're doing here is at page 4, line 41, striking the word practices, spelled Pracitces, and substituting the word practices. I think the reviser could have probably fixed this, but we'll do the work of the reviser. And so it'll be probably the only time this evening that I'm urging an aye vote on something the sponsors wish, but I urge an aye vote.
The motion is the adoption of changing practices to practices. L28. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. L28 is adopted. Senator Winter.
Thank you, Mr. Chair. With those amendments, which I want to thank the stakeholders for doing, we've brought the higher ed community into a neutral position. We've worked long and hard over many years with the business community, and where we've come to today is a result of many hours of conversation. And what this bill ultimately does right now is replace severe pervasive with a modernized definition of harass and harassment. And this isn't just sexual harassment, it's also racial discrimination, discrimination based on religion, discrimination based on all our protected classes. There's been instances where within our courts and within case law, rape was not pervasive enough because it was a one-time only instance to create an unsafe work environment. There's been instances where the use of the N-word wasn't severe enough to create an unsafe work environment. So I want to put you in the place of going to work where a rape occurred or the N-word is routinely used and see if you're going to show up and be your best self and your best employee and do your best work. And yet, again and again, these cases haven't gone through the court system in the way that we expected to protect workers. But what's actually worse is when employees go and ask if they have a case, they're told no. It's not severe enough, it's not pervasive enough. We need a modern definition, and that is at the heart and soul of this bill. And we've worked really hard to make sure that that definition is clear and understandable to everyone involved, to ensure that every single person that shows up for work in Colorado feels safe. And that's what this bill does. It also modernizes non-disclosure agreements. It also expands protections for folks with disabilities. And what I think is really important here is it's modernizing an employer's affirmative defense. We are not saying that employers are bad people. Things happen. We know folks are trying to create a safe workplace, and we're saying if you do things like respond to a complaint, you provide training, you let folks know what your policy is and that harassment is not something that you accept. Racial discrimination, religious discrimination isn't something you accept. If you do the work to be a good employer, we're giving you an affirmative defense. And then we are also treating marital status consistently. And so we've worked a lot on this bill. I want to thank all the stakeholders, both proponents and opposition, to get where we are today. And I urge a aye vote.
Seeing no further discussion from Senator Gardner.
Thank you, Mr. Chair, and I appreciate your patience. I was trying to see if any of these amendments, which I've just now seen, address any of the many concerns I have about this bill. Unfortunately, I haven't had time, and so if I speak to something that the sponsors believe has been addressed by their amendments, one, my apologies, and two, I invite them to tell us how they have. This bill is a sea change, if you will, in the law of harassment and discrimination in Colorado. It is unnecessary. I'm sure the proponents don't believe that, but in my view, it is unnecessary because, in fact, so many of the cases we heard about in committee, horror stories, by the way, and I don't exaggerate to say that, the fact patterns were egregious. But as they were presented, I recall asking one witness who presented really a terrible story of what had happened to her, and complaining and suggesting that we needed to change the standard for what constitutes sexual harassment in the state of Colorado. And there was an implication that somehow, if we changed the standard, that this would not, that the events of which she reported would not have happened to her. In fact, they were so egregious that I had to believe that they constituted severe or pervasive conduct on the part of the employee. And that particular witness, when asked, well, did you file a complaint with the Civil Rights Division or with the EEOC? Did you do anything like that? And what happened? Because I was unbelieving. And the answer is, well, no, I didn't do that. And where I was left with that particular testimony was, well, our standard's quite adequate. We need to ensure that people are able and know, and we can't make them complain, and if they don't feel comfortable complaining, that may be despite all of the process and all of the practices and all the safe spaces that are created by employers today. But nevertheless, it doesn't go to the standard. Another witness told an egregious story that facts that came from the 10th Federal Circuit, that is the circuit here that Court of Appeals that governs Colorado, about a case that happened at an auto dealer in the 10th Circuit, the assertion being that this terrible, terrible stuff that was, and it was indeed, was not severe or pervasive, or wasn't held to be severe or pervasive by the court. One thing about being there all night, as we were, was and one thing about being there all night with your computer and subscribing to legal research databases, you can look up the cases, and so I looked at this case and found, and this was a lawyer who had represented that this was the case, found a 25-year-old case from Utah in which the 10th Circuit had basically said no. The district court was very wrong and cited case after case after case to show that this was severe or pervasive conduct, that it did constitute sexual harassment. Now, that plaintiff was not successful. That plaintiff was not successful for a wholly different reason. And in fact, there have been amendments in 1991 to the standards of Title VII that would have changed the outcome of that case, and yet it was presented as a reason that we needed Senate Bill 172. Now, the interesting thing about this, and was shocking to me, and I don't know what the answer to this is now, was that the director of the Colorado Civil Rights Division testified in the committee hearing that they opposed the bill. I don't know what their position is today. They haven't called me and shared with me, but the testimony I heard in committee was, we oppose this bill. And the reason they oppose this bill is because they have a work-sharing arrangement with the federal government under the Title VII and the EEOC process, because they do dual investigations. CCRD investigates a complaint that's made to CCRD and to the EEOC, or if the complaint's made to EEOC and the complainant says, yes, I want this to be a CCRD complaint as well, then one agency or the other investigates it on behalf of them. And it turns out that this is quite the business for the state of Colorado. Some $672,000 flows into the CCRD coffers to do those investigations. If they did not receive that money on a dual case work share, the division would be out $600,000, a good part of their budget. That's because the Title VII standard, which the director said was not an impediment to the finding of hostile work conditions and sexual harassment, racial harassment, the severe pervasive standard worked quite well. But if we change the standard, their work-sharing agreement with the federal government goes into question because we don't have the same standard any longer. The other issue is that we have new requirements in the non-disclosure agreement. And if you bear with me, Mr. Chair, I'll turn to the bill. The non-disclosure portions of the bill start at page 11. And if you'll follow along with me there, it adds a section to 2434 in the Colorado Revised Statutes, section 407. It's entitled Non-Disclosure Agreements, Requirements for Enforcement, Penalties for Noncompliance. It says a provision in an agreement entered into or renewed on or after the effective date of this agreement between an employer and an employee or a prospective employee that limits the ability of the employee or prospective employer to disclose or discuss either orally or in writing any alleged discriminatory action or any alleged discriminatory or unfair treatment, which provision is referred to in this section as a non-disclosure provision, is void. So it takes a voluntary provision between the two parties and voids it unless. Now I have to compare it with the committee report. We're on page 11 and 12. So when you do this, you find, and this is what happens when you do bills this quickly, on page 11, line 1, you strike actually, I'll go to page 11, it's lines 26 and 27. And you have to walk through and do this so you know what's in the bill. Because we just passed this committee report, but it's, and I don't know if you have the time to go through each and every one of these and do the strike-throughs with committee reports. I certainly don't. So far, so good. What's in the bill remains in the bill, even after the committee report. A provision in an agreement entered into or renewed on or after and so forth is void unless and we do turn that into page to 2334-408, but page 12, line 14. So it's void unless the non-disclosure provision applies equally to all parties to the agreement. Okay, well, I will tell you that as a person who's from time to time does one of these agreements, it turns out that that's generally in an agreement, and if the employee wishes to have that term, it will be there. B, the non-disclosure provision expressly states that it does not restrain the employee or prospective employee from disclosing the underlying facts of any alleged discriminatory or unfair practice. 2, and we're still going along here, and then we strike, line 14, we strike 2, and substitute including disclosing the existence and terms of a settlement agreement to, I guess that's just a clarification, the employees or prospective employees' immediate family members, religious advisor, medical or mental health provider, legal counsel, financial advisor, or tax preparer. Once again, as one who does these agreements from time to time, that's a standard provision. So, okay, on the one hand, I don't have a lot of problem with it. On the other hand, why are we doing that one? 2, to any local, state, or federal government agency for any reason, including disclosing the existence and terms of a settlement agreement without first notifying the employer. Well, turns out that is in these agreements. So that's fine. In response to legal process, such as subpoena to testify at a deposition or in a court, including disclosing the existence and terms of a settlement without first notifying the employer, and that's a typical provision as well. And for all other purposes as required by law. Well, turns out that two people can't agree to not do something that's required by law, so that's not there. So what could this be about? Oh, let's get here. The non-disclosure provision expressly states that the disclosure of the underlying facts of any alleged discriminatory or unfair employment practice within the parameters specified in subsection 1B of this section does not constitute disparagement. Now, how does that work? Let's see. The non-disclosure provision is void unless the non-disclosure provision expressly states that disclosure of the underlying facts within parameters specified in subsection 1B of this section does not constitute disparagement. Well, I don't know that that's in a lot of agreements I've seen. But those agreements say that disclosure is permitted, and it has a non-disparagement provision that says you're not to disparage them. And the only way you can make the two of those provisions work together in reasonable contract construction or statutory construction is that it would be this way. So I don't know what that's about. Then we get to page 13. This is another void unless, but I'm reading the bill and I'm reading the committee report, and it turns out there's a change here. Unless the non-disclosure provision is void unless, and you go over to the committee report, and you have to read that language, not 3 through 9 in the bill, but you have to read this language in the committee report. It says, void unless the agreement includes a condition that if a non-disparagement provision is included in the agreement and the employer disparages the employee or respective employee to a third party, the employer may not seek to enforce the non-disparagement or non-disclosure provisions of the agreement or seek damages against the employee or any other party to the agreement for violating the provisions. Well, that's the imposition of a condition on the non-enforcement. Okay. It's not so unreasonable. Then we get to any liquidated damages provision of the agreement does not constitute a penalty or punishment, and to be enforced, the liquidated damages must provide for an amount of liquidated damages that is what? Reasonable and proportionate in light of the anticipated actual economic loss that a breach of the agreement would cause, and not punitive, and an addendum. Now, this is the problem to me. This is just kind of a gotcha. Let me let me digress here to talk about liquidated damages in the law. Now, liquidated damages mean damages that are agreed. They're liquidated on the front end. So, when parties enter into a contract, and these settlement agreements are contracts, they often on the front end don't know what the damages will be if one or the other breaches. And in fact, contract damages can be difficult at times to quantify. And if you can't quantify them, even though the court knows you had damages, the court won't award them if you can't prove them. And they'll say, well, we know you had some, but I don't know what they are. Maybe it's $1 and maybe it's $1 million. I just don't know. And there's rules about foreseeability of damages and so forth. So the practice has arisen for parties to put liquidated damages into their contracts, an agreed amount of damages. Now, you see it in construction contracts, and this is to the bill because it has a description of what liquidated damages are and that they can't be punitive and so forth. So I really have to explain this area of the law to you. Liquidated damages might be used in a construction contract where they say, well, if you're a day late, the liquidated damages for that is going to be $5,000 a day if the project's not done on time. Now, that allows the owner of the construction project to not have to prove, because they have some damages. If the project's not done on time, there's got to be some damages associated with that, but it's very hard to prove. So people want their construction project done on time. They want their contract complied with. So the practice has arisen somewhat, or did arise somewhat in the law, that a party would say, well, the liquidated damages for not being done on time, or the liquidated damages for a breach, will be $1 million a day. When, in fact, $1 million a day was more than the project was even worth. And so you'll find in the restatement of the law, which is done by the American Law Institute, and I think we're probably on the restatement second or third, that liquidated damages are enforceable when? Well, something along the lines of when they're reasonable in proportion and in light of the anticipated actual economic loss, and not a penalty, meaning they're not punitive. Well, guess what? That's what this says here. Liquidated damages provision does not constitute a penalty or punishment. And to be enforceable, the court would have to follow the common law of contracts, accepted in every jurisdiction in this country. Why would we put that in statute? It's the law. It's the common law. What we really did here is put in a gotcha. Because not only if you have a non-disclosure provision, it's void unless you do all of these things. Well, this is really made to be a trap. Because you've got to have an addendum signed by all the parties to the agreement and attesting to compliance with subsection 1 being attached to the agreement. Well, That's a gotcha. Generally, people have to sign the agreement. Now they have to do an addendum that has all of these things in it for subsection 1. Which is that, if I understand this correctly, that it comply with all of these things that go before it. It's just a gotcha. Now, there is language that says, following this on 13, that says, each instance when an employer includes in an agreement a non-disclosure provision that violates subsection 1, it constitutes a violation of this section, and the employer is liable for actual damages and a penalty of $5,000 per violation. Well, that's pretty interesting. Why is it pretty interesting? Well, earlier in this very bill, 2 paragraphs before, there's a provision that says you, employer, can't have liquidated damages unless they're reasonable and proportionate in light of the anticipated actual economic loss and not punitive. And in the next breath, what the drafters, what the proposers of this legislation have done is impose a punitive requirement on the employer. A penalty, and they call it a penalty. Think about that. Employer, you cannot impose liquidated damages that are not a penalty, and you can't anyway because the common law says you can't. But we then turn around and say, oh, but in the case for the employee suing the employer, we're going to impose a penalty. We're going to statutorily override the common law and say there's going to be a penalty of $5,000. Where is the fairness and equal treatment in that? Goes on, the commission and any employee or prospective employee who is presented with an agreement that includes, and I'm trying to remember whether we had a change in this. This is page 13. It seems to still be in the bill after the committee report. The commission and any employee or prospective employee is presented with an agreement that includes a non-disclosure provision that violates subsection 1 of this section may immediately bring an action for injunctive relief and to recover penalties. Remember the penalties, the same kind of penalties that we outlaw for the employer, or outlaw for the employer seeking against the employee. We turn around and we say, you have a cause of action, employee against the employer for penalties. And in addition to penalties, an employee may recover actual damages, reasonable cost, and attorney's fees. Now, by the way, one of the things that's axiomatic in the law of damages is that you can't recover twice. you can't recover your damages twice, unless you got some provision that says you get treble damages or double damages. But in common law, if I can prove damages for the loss of my automobile, I can't collect damages twice. But here, you're going to be able to do that. You're going to recover actual damages, and you're going to recover the penalty damages. And more importantly, reasonable cost and attorney's fees. You know, the plaintiff employee bar did a very fine job of drafting this, but that's what it is. It's not drafted in any semblance of fairness or even handedness. It was drafted by the plaintiff employee bar. And then, insult to injury, the final paragraph says, in any civil action involving a claim of a discriminatory or unfair employment practice, a plaintiff may present evidence that the employer against whom the action was filed entered into one or more agreements that included a non-disclosure provision involving the conduct of the same individual or individuals who are alleged in the action to have engaged in discriminatory action. If such evidence is presented, it's considered evidence in support of an award of punitive damages. We don't like penalties when an employer enters into a voluntary contract with the employee, but we don't mind imposing penalties and punitive damages when the shoe's on the other foot. Now, there's a lot more to be said about the affirmative defense, but I don't want to take everyone else's time here. There's only 4 hours left between now and midnight, and so I would encourage colleagues perhaps to talk to this, and I would also encourage the sponsors, if I have missed anything that would have been corrected by any of their amendments, to address those matters.
Senator Gonzalez.
Thank you, Mr. Chair. I want to extend my appreciation to the good senator from Colorado Springs for always making me check my clock. Grateful for his comments. I do, though, however, want to correct the record on one point specifically. And that was some testimony that we heard from the CCRD during our Senate Judiciary Committee that raised some concerns for us as co-prime sponsors. So we reached out to the EEOC, the Equal Employment Opportunity Commission, and actually here we're able to receive a letter in regards to the CCRD's testimony. And I just want to read from that letter dated April 18th, 2023, from the Director of the Office of Communications and Legislative Affairs for the EEOC in Washington, D.C., who then states, quote, after becoming aware of the CCRD testimony referred to in your letter on April 13th, 2023, the EEOC emailed the CCRD to inform them that their testimony before the Colorado Senate Judiciary Committee miscommunicated the EEOC's position relative to the state's agencies, relative to the agency's work sharing agreement and funding contract with CCRD and Fair Employment Practices Agencies, FEPAs, in other states. Now I want to highlight, bold and underline this following part. We emphasized that the proposed changes in Colorado law would not jeopardize the EEOC's work-sharing agreement or funding contract with the CCRD. We are continuing to follow up with CCRD to further clarify the EEOC's position and respond to their questions concerning the agreement's operation. Now, I name that because this is an argument that has been raised that passing this policy would impact our bill, and for that reason, I ask for an aye vote on Senate Bill 172.
Senator Will.
Thank you, Mr. Chair. I want to come up and have a little bit of a discussion about this bill. I've had quite a bit of experience working for the state, understand a little bit about some of these harassment issues with employment. I was looking under Section 4 under the definitions. We were talking about whether the conduct would be offensive to a reasonable person in the same actual or perceived protected class or who shares the same or similar characteristics as the individual subjected to the conduct must be determined by a review of the totality of the circumstances of conduct. The totality of circumstances applies a lot in several areas of law, the totality of circumstances. That means the type of conduct, the nature of the conduct, and here's a good one, is the frequency of the conduct. So I think under this law, the frequency doesn't really play into this. Something can be offensive or considered harassment, recognizing that a single act of harassment may be offensive to a reasonable person. That also falls under the totality of the circumstances. We get down to about talking about the harassment claim under the subsection 1A. The legal standard for harassment does not vary by type of workplace. It's irrelevant that a particular occupation may have been characterized by a greater frequency of discriminatory comments or conduct in the past. I have to say, under the state employment, one of the best employees I ever had was an administrative assistant. And I remember when I interviewed this young lady, she was seemed extremely naive, very sweet, just a great person. And I thought, I don't know for the job that I'm potentially hiring her for, that she could take it because of, and going back to being irrelevant to the particular occupation. Well, there's a big difference whether, I guess, if you're probably working as an admin in an office or that you're out on a construction site, not to pick on any kind of construction work or anything like that, but sometimes that can be in an environment that is a little tougher, especially if you're easily offended maybe by language, maybe innuendos, those type of things. Sometimes a particular class of workers can be a little, I guess for the lack of better terms, can be a little rougher work environment than others. So I spoke to this about this young lady that I hired, and I was very concerned that I hired her to work around a whole crew of game wardens, and I'll have to say sometimes there's instances that their language isn't perfect. And I remember telling this young lady, I said, you have every qualification for this job, but what this very bill is talking about is I was concerned because obviously I wouldn't want her offended, not that there would be anything, any kind of harassment or offensive things that would be directed towards her or in that manner, but you would actually be hearing it maybe as a side conversation. And I remember telling her, I said, I don't know if you can handle working for us, because I don't want you offended. I don't want you to feel like you're being harassed in any manner. And this, as I told you before, this young lady turned out to be the best employee I ever had. And I'll also mention, without mentioning her name, and she still works at that job and does an excellent job and will retire from the state of Colorado in that position, I promise you. And so we also talk about the classification of employees and refusing to refer an individual for employment as no one for available job is otherwise qualified because of disability, race, creed, color, sex, sexual orientation, gender identity, gender expression, marital status, religion, age, national origin, or ancestry. Well, that's there in law. We all understand that. And these are the type of things I'm not talking about, that I had my experience with those employees, and like the young lady I was speaking of. There's and then you move on into page 8. I was looking at the on section C, for a labor organization to exclude any individual otherwise qualified from full membership rights in labor organization, to expel an individual from membership in the labor organization, or to otherwise discriminate against any of its members in the full enjoyment of work opportunity because of disability, race, creed, color, sex, sexual orientation, gender identity, gender expression, marital status, religion, age, national origin, or ancestry. I know from past, I wonder if this applies, does it apply to an employee that maybe doesn't want to join a labor union or labor organization? That's concerning to me because I know there's lots of times there's pressure in employment that you have to be part of that labor organization to do the work. And also, moving on to page 9, to deny or withhold from any qualified individual because of this disability, race, creed, color, sex, sexual orientation, gender identity, gender expression, marital status, religion, age, national origin, or ancestry, the right to be admitted or participate in any like training programs or on-job training programs or any other occupational instruction, training, or retraining program. I can tell you in my 40-plus years of experience, I never once saw any of that happen. People wanting to make themselves better, make them a better employee, become more adept at their job. Never seen that happen. Then I move on to page 10. This talks about when there is a harassment claim. When an employee proves that a supervisor unlawfully harassed that employee, and the employer may assert an affirmative defense to the harassment claim only if the employer establishes that the employer has established a program that is reasonably designed to prevent harassment, deter future harassers, and protect employees from harassment. I'm only speaking from my experience from government and state employment, the state government of Colorado. all of these things are already in place, already within the law. So I don't know exactly what this is starting to, what we're trying to get to right here with this bill that's not already there, other than it may change in the law as I was reading it. I think this bill actually weakens what's already in statute and what's already in law. I think this bill actually weakens that for some of these employees. That's the way I'm reading it. And then there's also the part about where the employee has unreasonably failed to take advantage of the employer's program specified in section 1.5A of this section as established by the totality of the circumstances. Everywhere throughout this bill, we talk about the totality of circumstances. And I think everyone understands what the totality of circumstances are. That's a term that's used throughout law, whether it's this type of law or any other criminal law. The totality of the circumstances is everywhere throughout our statutes. We're talking about the reasonable and proportionate in the light. This is about the liquidated damages provision. And in an agreement does not constitute a penalty or punishment, and to be enforced, a liquidated damage provision must provide an amount of liquidated damages that is reasonable and proportionate in light of the anticipated actual economic loss that a breach of the agreement could cause. And then right underneath that it says it's not punitive. I think that's open to debate whether it's not punitive. Anyway, I've looked through this law quite a bit. I think I've made a pretty good assessment of it. I think what's already in statute for concerning protections for Colorado workers, and for that against discriminatory employment practices, I think it's already in law, and I think that this bill actually waters down and reduces what is currently in law. So, thank you.
Senator Van Winkle.
Thank you, Mr. Chair. Now, I actually have seen this bill before. I recall there was something similar in the House a couple years ago. I believe it was Senate Bill 21-176, and the bill was moving through the process. It actually, I don't think it did get through the Senate, but unfortunately in the House, the committee as a whole took a look at the issue and decided not to move forward with the policy then, and I believe that was the right choice at the time. The House Judiciary Committee examined its implications upon the people of Colorado and found that the harm done by the bill would far outweigh the benefits of the bill at that time, and this bill looks strikingly similar to that, and I think the same thing could be said about this bill, that it could harm more than it does good. Now, it does make a number of changes to anti-discrimination law. It adds marital status as a protected class, and it rejects a severe and pervasive standard. My apologies, a little bit of migraine here, I think. And that's on page 4. Now that is a major change in state law. It's a significant change to a legal standard that has existed for as long as I have known, that severe and persuasive standard. And it creates actually a jurisdictional federal versus state problem, because a lot of times the federal government will have a complaint or something and they push it essentially to the state of Colorado in order to deal with that. But the problem is if the state of Colorado has a very different standard than the federal government, then the duality of complaints completely falls apart, and they're essentially looking at the same incident, whether it's a federal government or state government, where the federal government's using the state government in order to look into this, creates a serious problem. Now, the standard, that's for harassment claims, but instead it defines harassment as an unwelcome conduct or based on someone's protected class or submission to the conduct is either an explicit or implicit term of an individual's employment, and the conduct is both objectively and subjectively offensive. Now, the bill also makes it an unfair employment practice for the employer to fail to conduct an investigation into a harassment complaint. To establish an affirmative defense to an unfair employment case, the employer must demonstrate that it has first, and there's a whole series here, that the establishment of an affirmative defense. Now, the first one there is the establishment of a program to prevent harassment. 2, it must maintain records of all complaints and retain those records for the duration of the employer's operation plus 1 year afterwards. 3, communicated the existence of the program to employees. That's given. 4, within 5 years of using the affirmative defense, no employee has submitted a complaint. And 5, the employer has unreasonably failed to take advantage of the program. Now, finally, the bill makes changes to non-disclosure agreements, NDAs, non-disclosure agreements. If an employer violates the NDA provision, it is liable for actual damages plus $5,000. An NDA is void unless it applies equally to all parties. It does not restrain an employee from disclosing discriminatory conduct. 3, it expressly states disclosure of discriminatory conduct, doesn't constitute disparagement, or 4, liquidated damage don't constitute a penalty. And 5, lastly here, there is a signed addendum attesting to the compliance is attached to the NDA. Now, when you take all this into account, we can safely analyze what its effects might be on the state of Colorado. Now, workplace harassment violates Title VII of the Civil Rights Act of 1964, among other laws. Workplace harassment is not accepted in the state of Colorado, and I don't believe in any state, but especially in Colorado, we have worked very hard to make sure that workplace harassment is not acceptable. And this law takes it a significant change, again, to that legal standard and everything else I've already gone through. Now, federal law defines it as unwelcome conduct. Now, this is workplace harassment, defines it in federal law as unwelcome conduct that is based on a protected class. Now, harassment becomes unlawful where, during the offense, conduct becomes a condition of continued employment, or 2, the conduct is severe or persuasive enough to create a work environment that is a reasonable person would consider intimidating, hostile, or abusive. Now, that is the current practice. This is an agreed upon standard and that has been very effective at weeding out workplace harassment and making it a thing of the past. This is agreed upon standard, so for the bill to reject that standard, so it takes that standard, which again does not allow for intimidation, it doesn't allow for hostility, it doesn't allow for abusive, it doesn't allow for harassing behavior or a behavior that may be unwelcomed. This rejects that standard. And to quote here, this court case from 1986, petty sights and noises in isolated incidents, unless serious, will not rise to the level of illegality. To be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive to a reasonable person. This standard helps protect employees by punishing truly bad actors while also not being overly burdensome on employers for frivolous claims. And that there speaks to exactly one of the issues that we may have with this bill, in that it will, in fact, lead to be overly burdensome on employers for dealing with several frivolous claims that can come at any time for things that do not rise to that level of intimidating, hostile, offensive, or otherwise harassment to the good senses of reasonable people. In rejecting that standard, we are potentially placing victims and employers in a legal limbo especially between, as I described, the federal and state governments, which would have then two different standards for looking at the same exact cases. Now, additionally, the bill places an unreasonably high burden on employers to defend against any unfair employment practice claims. There are 5 elements to prove in an affirmative defense. If any one of these elements is not met, the employer does not have a defense. One of these elements, that is within the last 5 years, no employer has submitted a discrimination complaint. This does not successful complaint or non-frivolous complaint. It says any complaint. This can be egregiously abused. Any negative review or comment could be claimed as retaliation under this bill, which makes employment in the state of Colorado all the more harder. We already hear often, need not hire from the state of Colorado, and this bill will make it even more so, especially as large companies are trying to move here perhaps, or there's, I can think of one aerospace company that already has a large footprint in the state of Colorado that wants to increase it ever more. They are located largely in Jefferson County, right on the border of, the senator from Teller County and the senator from Douglas County. Myself, it's located right on that border is their main, but they have offices all over Douglas County, all over especially the southern half of Colorado, and even in Boulder and other places. They are looking to expand even more, but this is the kind of bill that will make them scared to move to Colorado and hire employees that could essentially create frivolous claims that are never ending. Though everyone deserves to work in a safe environment, by trying to create our own legal standard, which is separate from all other states, separate from the federal government, we ignore the protections already in place for employers and potentially make it more difficult for both employers and employees to function in a workplace. And I just want to go back one more time to 2 separate points. One is that this is a significant change to the legal standard. The legal standard right now does not allow for legal harassment to be things that are essentially petty or annoyances or just perhaps someone looked at me wrong, something like that. But it will rise to the level of illegality, and that is something that we have clearly taken care of in several years, the past several years, as we've seen. Now, I am wrapping up my remarks here on basically the bill right now is written and could get companies pulled into a lawn court case for even just a single comment. We heard this over and over in committee that a single comment could get an entire company pulled into court for years based just on a single comment that is not intimidating, not hostile, not offensive to a reasonable person, but is something more of an annoyance, something a little more petty, and that is one of the major dangers of this bill. Thank you, Mr. Chairman. I do appreciate you hearing my opinion.
Senator Gardner.
Thank you, Mr. Chair. The thing is, this bill is as I said earlier, a sea change with respect to I'm going to have to step away, Mr. Chair, for another document, and someone else may wish to speak at the mic.
Mr. Majority Leader.
Thank you, Mr. Chair. I move Senate Bill 172 lay over to the end of the calendar.
The motion is to lay over Senate Bill 172 to the end of the calendar. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. That bill will lay over. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee proceed out of order for the consideration of House Bill 1077.
The motion is to proceed out of order for the consideration of House Bill 1077. All those in favor say aye. Aye. Opposed, no. Ayes have it, and we will proceed out of order for 1077. Will the clerk please read the title of House Bill 1077?
House Bill 1077, Representatives Wolford and Garcia, Senators Winter F. and Hawkins Lewis, concerning a requirement to obtain a patient's informed consent before performing an intimate examination of the patient under specified circumstances and in connection therewith making an appropriation.
Senator Hawkins Lewis.
Thank you, Mr. Chair. I move House Bill 1077 and the accompanying committee report.
To the Health and Human Services Committee report.
Thank you, Mr. Chair. In the committee, we did 3 amendments. We restored the role of CDPHE to create a form that patients could use. We also made it explicitly clear that this policy does not apply in emergency situations or in the course of a healthcare procedure that is very urgent. And we also modified the definition of intimate exam, and we also said a provider must obtain a consent form for a preoperative appointment or as soon as possible prior to an exam occurring.
Is there any further discussion? Seeing none, the question before us is the adoption of the Health and Human Services Committee report. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. That report is adopted. To the Appropriations Committee report. Seeing no discussion, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. That report is adopted. There is an amendment at the desk. Will the clerk please read L009?
Amendment
Senator
L00.
Winter.
Thank you, Mr. Chair. L009 clarifies the complaint process and how to report to the department, and I encourage a yes vote.
Is there any further discussion? Seeing none, the question before us is the adoption of L009. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. L009 is adopted. There is an amendment at the desk. Will the clerk please read L010?
Amendment L010 by Senator Winter F. Amend the Health and Human Services Committee report dated March 30, 2023, page 1, strike lines 13 and 14. and
Senator
subsequent.
Winter.
Thank you, Mr. Chair. I move L010.
Is there any discussion? Seeing none, the question before us is the adoption of L010. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. L010 is adopted. To the bill.
I believe we have another
Senator Hawkins
amendment.
Lewis.
We have another amendment, Mr.
Oh, there's another amendment coming.
Yeah.
Will the clerk please read L011?
Amendment L011 by Senator Smallwood.
Senator
Amendment-
Smallwood.
Thank you, Mr. Chair. I move Amendment 11.
To the amendment.
Colleagues, I worked with the sponsors and the proponents of House Bill 1077 about this particular amendment, just clarifying some more information around damages and how they're calculated. And I believe the sponsors would view this as a friendly amendment and would ask for your aye vote.
Senator Winter.
Thank you, Mr. Chair, and I want to thank the good senator from Douglas County for working with us to ensure that we were moving to a place that this was enforceable. There was incentives to ensure that uninformed consent didn't happen in a way that everyone felt worked. And I think after several back and forths, we found a good balance, and I urge a yes vote on this amendment.
Is there any further discussion of L011? Senator Gardner.
Thank you. I appreciate the sponsors' willingness to entertain this, and we did a lot of work on it. I want to thank the senator from Douglas County as well for working on it. This is a really great amendment. It's friendly. It greets everyone warmly whenever it encounters them, and so I hope we will have an aye vote in the chamber.
You buying time? Senator Winter.
Thank you, Mr. Chair, and to the good senator from College Springs. This amendment treats everyone warmly with consent that you are receiving the amendment, and so I encourage this vote.
The chair appreciates puns. Is there any further discussion? Seeing none, the question before us is the adoption of L011. All those in favor say aye.
Aye.
Opposed, no? No! Ayes have it, and this very friendly amendment is friendly adopted. Senator Winter.
Thank you, Madam. I'm sorry. Thank you, Mr. Chair.
Look,
I apologize. Thank you,
gender is
Mr.
fluid.
Chair.
We're good.
I want to use your correct pronouns. I move that we pass 1077 as amended. This is a bill that ensures that when you are sedated or unconscious, you don't have intimate exam against your consent. So, and this is gender neutral. This is about rectal exams, prostate exams, vaginal exams, and one of the things, this bill came to me from my constituents who were nervous about accessing the healthcare system, thinking that this is something that could happen to them without their consent, that they wouldn't know, that they were going to be used for educational purposes without them knowing. This is going to protect patients. This also protects the people learning from these exams because they don't want to be put in a place to perform these exams without consent. And so this is protecting students, it's protecting patients. This is common sense, and I encourage a yes vote.
Madam Chair appreciates it's gender neutral. Senator Jaquez Lewis.
Thank you, Mr. Chair. I just reiterate my excellent co-prime from Westminster and all the work that she has done. As a healthcare professional, I think we saw in committee that students do not want to be put in that position, and anyone living in a state without a law banning this is vulnerable. So let's be very clear about this. Consent matters. All parties, all genders, every context, every situation. This will prohibit these kind of intimate exams to be performed while the patient is sedated and unless the patient has given explicit written consent. So we ask for your aye vote.
Senator Smallwood.
Thank you, Mr. Chair, and thank you, colleagues. So just to be really clear, if you take a look at the committee report from Health and Human Services Committee, you will see a number of amendments that were made in committee. Obviously, we passed a number of amendments today. To me, this is an example of how I think as a body, we can all come together with a concept, first of all, to come to the recognition that there are some medical procedures that over time, over decades, might have at one point seemed acceptable, logical, medically necessary, and that over time not only proved to be anachronistic, but actually sort of embarrassing that these procedures were even happening in modern times. So not only am I in support of the concept, and actually always have been, I've been really clear with the sponsors and the proponents about that, but a lot of times you've heard me come here to talk about the devil being in the details, and I cannot think of a single detail in this bill that the sponsors have not only addressed, but rectified and done so, I think, in a really open and transparent and very collegial way. So again, I want to thank the sponsors. I'm definitely an aye vote on House Bill 1077 and hope that you would be as well. Thank you, Mr. Chair.
Thank you, Senator. Senator Belton.
Thank you, Mr. Chair. I come up, I want to thank the sponsors for all the work they've done on this bill. This is just horrific to even think we have to have a bill to rectify this. You know, the medical profession takes oaths of ethics and things, and to just think that they go against that just blows me away. But thank you for all your work you've done, working across the aisle to make this bill a very good one that I can support and vote yes for. So thank you.
Is there any further discussion? Seeing none, the question before us is the adoption of House Bill 1077. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. That bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
The motion is for the committee to rise and report. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. The committee will rise and report.
Yeah.
Senate will come to order. Senator Bridges.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Will the clerk please read the report?
Mr. President, your committee of the whole begs leave to report it has had under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. House Bill 1077 is amended, passed on second reading, and ordered, revised, and placed on the calendar for third reading and final passage.
Senator Bridges.
Thank you, Mr. President. I move the report.
The motion is adoption of the committee of the whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, committee of the whole report is adopted. House Bill 23-1077 is amended, passed on second reading, and ordered, revised, and placed on the calendar for third reading and final passage. Majority Leader Moreno.
Thank you, Mr. President. I move that the balance of the general order's second reading calendar lay over until later this evening.
The motion is to lay over the balance of the general order second reading calendar to later on this evening. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the balance of the calendar will lay over to later on this evening. Majority Leader Moreno.
Thank you, Mr. President. I move that the Senate take up the following Senate bills on special orders second reading at the hour of 8:47 p.m. Senate Bills 266, 276, and 265. Colleagues, you have calendars at your desk. It originally included 259. That is taken off special orders this evening, so that will not be taken up on special orders.
The motion is that the Senate take up Senate Bill 266, Senate Bill 276, and Senate Bill 265 on special orders at the hour of 8:47. This requires a two-thirds vote. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The motion is adopted. The Senate will take up Senate Bills 266, 276, and 265 on special orders at the hour of 8:47 p.m. Senator, special orders, second reading of bills. Senator Bridges.
Thank you, Mr. President. I move the committee resolve itself into the committee. I move the Senate. It's the third time I've done that. From the top. Thank you, Mr. President. I move that the Senate resolve itself into the committee of the whole for the consideration of special orders, second reading of bills.
You've heard the motion. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the motion is adopted. The Senate will resolve itself in committee of the whole for consideration of special orders, second reading of bills, and Senator Bridges will take the chair.
Accused of dragging.
The committee will come to order, and the code rule is relaxed for everyone. I can relax at 4. Will the clerk please read the title of Senate Bill 266?
Senate Bill 266, Senator Priola, Representatives Brown and Kipp, concerning a requirement that the Commissioner of Agriculture designate neonicotinoid pesticides as limited-use pesticides. That was good.
Senator Priola.
Thank you, Mr. Chair. I move Senate Bill 266 and the committee report from Agriculture and Natural Resources.
To the Ag report.
We had one amendment in Ag which implemented a compromise that was thoroughly stakeholdered. Ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the adoption of the Agricultural and Natural Resources report. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. That report is adopted. To the bill. Senator Jaquez Lewis.
Thank you, Mr. Chair. So let us tell you what all the buzz is about. We need to create a healthier habitat for our pollinators, and Senate Bill 266 takes the sting out of the harmful impact of neonicotinoids. Colleagues, who would like to hear what neonics are? Okay, really quickly.
Tell me what's happening.
Really quickly, neonics affect the central nervous system. They're hydrophilic. They're absorbed by the plants so that when the bees land, it goes right into their central nervous system. $5,000 to $10,000 times more toxic than DDT to bees. They absorb into bird eggshells, and that's why they're affecting our hummingbirds. So please join us on Senate Bill 266 by voting aye.
Senator Pelt.
Thank you, Mr. Chair. I'm not going to even attempt to match the good senator from Boulder County's puns. I was a no vote in committee, and the reason why is, anytime we make any nibble around the edge of any pesticide, it can have detrimental effects. I thank the sponsors for exempting ag, for doing all the work they did with their amendment to kind of take the weekend warrior out of the picture, and that we can still, buy it out in rural Colorado at our co-ops, at our local chemical retailers out there. So I do appreciate that. Again, I was a no vote in committee, but I do appreciate all the work that was done on this bill, and so thank you.
And the other, Senator Pelton.
Thank you, Mr. Chair. The agriculture Senator Pelton's, I guess, huh? Anyway, I would like to thank the sponsors. I was a no in committee. I agree with the good senator from Cheyenne Wells. But I would like to thank the sponsors for this part of the bill, because this was the part that really concerned me, is that neonicotinoids also control lice and bed bugs. And that is a very important part of why we need neonicotinoids, and also for agriculture and exempted ag, and I appreciate that as well. But, yeah, right, but I'm just saying that the bed bugs are a very important part. It's pretty much the only thing that really kills bed bugs, and that's something to control them. So I appreciate all the work that you guys did in this, and moving forward, but I'm still gonna be a no, but I still do appreciate your work, so thank you.
Senator Simpson. Can you see me? I can. Thanks for coming down.
Thank you, Mr. Chair. I just wanted to get up and say neonicotinoids one time on the mic. Neonics. Again, likewise, I appreciate the sponsors' efforts here, and actually was a yes vote in committee. I know how passionate my colleague is around pollinators, both of you, and routinely in the course of the summer when I see pollinators in my yard. Last summer, sent pictures of them to the good senator from Boulder County to appreciate. Probably depending where you live. Look, I know pollinators are challenged across the state. It feels like probably urban centers are more challenged than rural parts of the state. It doesn't always feel like we have a huge challenge around pollinators in the San Luis Valley, but I do recognize the value and the importance of having them there. I did, again, vote in favor of the bill. I'm not sure how we're going to measure or gauge success in this space. Every time I read and try to get a better understanding of what the challenges are around pollinators, it tends to revolve around climate change and fragmentation of habitat. And certainly the weekend warrior issues in urban centers probably play a role in that. Again, it's just going to be difficult to measure success. I do hope it has a meaningful impact on the pollinator population, particularly in the Front Range. We've had this discussion before. I'd like to see us transition into other areas and create more pollinator habitat, remove turf grass from Front Range interests and replace it with drought tolerant and pollinator friendly vegetation. And I think that'd probably go farther than the efforts we're doing here about removing neonicotinoids from less than, they're not licensed professionals. So I appreciate the effort and do value your dedication to this space, and I'll continue to take pictures of the pollinators at my house and send to you over the course of the summer. Thank you, Mr. Chair.
How are your bees doing?
Be careful, Howard.
Senator Will.
Thank you, Mr. Chair. I also want to thank the sponsors on this bill. We're talking about how many pollinators and native bee species we have in this state, hundreds and hundreds and hundreds of them. And they're critical. We talk about it and this bill kind of refers to it from an agricultural standpoint, about apples, blueberries, cherries, strawberries, cucumbers, pears, apples, tomatoes, pumpkins. Anyone who raises a garden understands the need for pollinators. And in fact, my wife makes our beekeeper bring up lots of bees in the summer, so she knows her garden's good and well taken care of. What I wanted to talk about a little bit here about pollinators is we talk about the agriculture. I think the bill even says 1 out of every 3 bites we owe to pollinators. In my old business in wildlife, it was critical that we have pollinators and specifically bears, because bears use serviceberry, they use chokecherry, and they use gamble oak. Those 3 mass crops are the most critical bear food source in the state of Colorado. And so it's huge that, because there's billions and billions of serviceberry plants, chokecherry plants, alderberries, thin leaf alder, all these things that need pollinated just like the agricultural crops. And so it's critical, and if we have a food failure year and the mass crops fail, sometimes that's from a freeze. Most often that's from a freeze, but also the pollinators come into play on this as well. And so that's where we get the bear conflicts in towns, specifically Aspen, Glenwood Springs, Eagle Vale, some of those areas on the west slope, also in the Grand Valley and Senator Rich's country too. But these pollinators and protecting pollinators does far more than just the agricultural aspect. And so I applied to sponsors, and I'll be yes on the bill.
With an addendum, Senator Pelton.
Thank you, Mr. Chair. And this really isn't another amendment, but I just wanted to further. I'd be remiss if I came up to this podium and talked about agriculture, and with, the advent of GMO crops, a lot less chemicals are being used in agriculture to help with the pollinators' survival out in rural Colorado. I saw a picture this morning, the peaches are blooming, so we need them for that, so I just wanted to come back up and say how agriculture and the technologies that just keep coming to the forefront are helping in this fight too, so thank you.
And another addendum. This is generating a lot of comments and repeat comments. Senator Will again.
Thank you. This is just a bit of trivia that I forgot to mention when I was up here the first time, but in my career I had the rare opportunity to work with a Forest Service employee that got their master degree from California, and her master's was on bees and pollinators. And we're talking about the pesticide side of this. It's really interesting. I learned a lot from working with this Forest Service employee, but do you know that there's a lot of bees that won't cross a road? So you put in a new road. It doesn't have to be a highway, just a regular road, and bees will not cross that. So there's lots of things to think about in development and the things we do and to protect our pollinators. So thank you.
Seeing no further discussion, the question you were sitting in your chair. It's hard to know someone wants to talk when they're sitting in their chair. It's a good thing your chair is so close. Seeing no further discussion, Mr. Minority Leader.
Thank you so very much, Mr. Chair. I just could start reeling off all sorts of bad puns, but I'll just join the hive. And I actually do have a couple of questions. The bill creates restrictions, and the bill creates a number of permissions. I'm just trying to understand the real world. I didn't have the opportunity to hear this in committee, and it interests me. And so I just have some questions that I'd like to understand a little more. Only pesticide applicators licensed under Article 10, this Title 35, may use the neonicotinoid. That's another good reason to come down, just to say neonicotinoid. It's a fun word to say, pesticides in the state. I'm curious how ubiquitous are those qualified individuals?
Senator Priola.
Thank you, Mr. Chair, and to the good senator from Monument. That's a very good question. So to the heart of the bill is that it restricts, it's not restricted use, but it's limited use, which is another level in the department that they will regulate. And through that, they will only be offered for sale at locations that are also licensed, which are usually like your co-ops, your agfinities, your rural implement stores. So going forward, folks who live in the suburbs and other members who came up and spoke referenced the term weekend warriors, which I would like to take credit in starting that term, because they're not licensed. Because, you know, they have an IT job or they're a teacher, and on the weekends they pill around in their backyard, but they have not gone through the process of getting licensed, which teaches them, you know, safety, how much to apply, how to read the back of pesticide, and how to mix it as far as ounces per acre, which it usually is because it's for ag, and trying to convert ounces per acre to your 20 by 10 foot yard is kind of difficult. Yeah, per foot. But most who have applicators license are either in agriculture, farmers, because they farm hundreds or thousands of acres, or they are pest control. The folks that the professionals you hire to come to your house to deal with your pests and so on and so forth. So these chemicals will still be allowed to be used in urban areas, but only by professionals who know exactly how much to use, when there are alternatives to use, or by professionals, i.e. Producers in rural areas who have the built-in incentive to use as little possible of said neonicotinoids, because, you know, they're applying over hundreds or thousands of acres, and every ounce counts, and it goes to the bottom line. So that's why I'm proud of the compromise that was struck. Is it's very precise, and it's easy. It's also easy to implement. It has zero fiscal note, and so I hope we answer your question.
Mr. Minority Leader.
Thank you very much, Mr. Chair. So what I'm trying to get the concept of the scope of the state. 64 counties, some of them are huge counties. How many potential licensed per county or something of that nature? Just trying to make sure that there is remaining adequate availability for those that would have use of these products.
Okay, and to the good Senator from
Senator Priola.
Okay, thank you, Mr. Chair. I think that's 307 locations. Okay. This is a list I have, if you want to review it, of all the retail locations that will still be available for purchase. Some of them are out of state, but they're licensed through, you know, current licensing and will still follow under the bill. So I don't have the exact number of folks who are licensed applicators, but I would submit it's got to be around 1,000 or so.
Mr. Minority Leader.
Thank you very much. It seems like we've got some data that says there's 307 licensed applicators in the state. Okay, so then licensed applicators or dealers. So applicators would be significantly more than the number of dealers. Dealers sell product, applicators apply product. And okay, fair enough. So the other piece of the puzzle is just context. A demonstration or a description of the harm, the need, and I get you opened the presentation with an explanation of how incredibly toxic these neonicotinoids are to pollinators, but describe what's the effect. I mean, the fact that they're toxic to pollinators is one thing, but is it actually a problem? Are the neonicotinoids available and being used in a way that is actually creating harm? So I'm asking for an establishment of the harm and the need for the bill, basically the kind of answer the why are we actually really doing this other than it seems like a good idea.
Senator Priola.
Thank you, Mr. Chair, and to the good Senator from Monument, thanks again for that question. So the real issue with neonicotinoids is that they're really quite effective in what they do. They mess with the neurological system of said insect that comes into contact with them and confuses them, and they're not able to find their way back or navigate as they normally would through their normal senses that they use to survive. So that's a problem, and that's what is leading to an inordinate amount of death. And it's one of the many areas where studies have shown that it's leading to a decrease in the populations of pollinators and such. So I think my co-prime sponsor has some more in-depth detail from a study, and I'll let her finish answering the question.
Senator Jaquez Lewis.
Thank you, Mr. Chair. Mr. Minority Leader, thank you so much for asking about this because it's a huge concern. We've had some critical journal articles in Science, for instance, Science magazine. The EPA has done some studies around 3 different types of neonicotinoids, and I'm going to try to pronounce them. Clothianidine, imidacloprid, and thiomexam. And they are, I'm just trying, but they actually can be 70% toxic to over 1,700 species. And so these neonics are really deadly. I hope that answers your question. I'll throw in that many countries in the world have actually, they just don't use them anymore at all.
Is there an old Nick? I know we have a neo-Nick. Mr. Minority Leader.
Thank you very much, Mr. Chair. I appreciate the additional elucidation of how toxic these are to the pollinators. That what I was kind of looking for was we can connect the use of neonicotinoid products to a depopulation that is 50% or 10% or 80% of the pollinators in an area previously, and we can specifically tie that to the neonicotinoids. That's kind of the real world, the establishment of the harm. What is the real problem? Not that the neonicotinoids are effective. Well, that's great. The chemical companies did a wonderful job of defining a chemical that had a very specific use, such as killing bed bugs. Everybody likes that idea. So I'm just trying to understand what has been the negative impact of neonicotinoids on pollinators in Colorado.
Senator Jaquez Lewis.
Thank you, Mr. Chair. There are some states that have actually done statewide studies on neonics on bees. We are currently one of them that has just started a study. So if you promise to come and ask me that question in a year, I can probably give you some really good data on where we are in Colorado and some of the causes that are, we know bee populations are dropping. We know that. So we're trying to figure out if we can do anything about all the different reasons. So I hope that helps.
Mr. Minority Leader.
Thank you very much, Mr. Chair. And one last question, and I think that the other prime sponsor might have an answer to the previous question as well. But why the exemption on wood coating product? That was one thing that I didn't quite understand. That just curious why.
Senator Jaquez Lewis.
Thank you, Mr. Chair. I would not have been able to answer that question either, except last year we had a stakeholder meeting with one of the only fellows in the state that uses a certain coating agent that it has neonics in it. And I don't know if it's resistant because of the bed bug thing. I don't know, but he uses it in his agent, and he really did a lot of begging and pleading for us to exempt him out. And so that's why.
Senator Priola.
Thanks, Mr. Chair. And some more items here on the previous question from the good senator from Monument. So EPA on neonics. January 2020, the EPA released proposed interim decision on neonics on the basis of protecting pollinators, including limiting when pesticides can be applied to blooming crops to limit exposure to bees, language on labeling to advise homeowners not to use neonicotinoid products, and canceling spraying uses of, I'm not going to try that one, it's too Greek for me, on residential turf due to health concerns. So this precisely cuts to the point of raising the bar on these to making them limited use, requiring those who purchase them to have an applicator's license, buy them from locations that are also licensed, because it's about a higher level of understanding on the proper time, method to apply, as well as measure and mix these pesticides. And it's right here. This is basically summarizes what the EPA has decided to move forward with this. And as my co-prime sponsor also mentioned, many other countries have banned the use of them. Canada is one per se. The EU has banned them for many years. It was part of my decision in carrying this and other bills in prior years. I researched what other nations around the world had done and the conclusions they'd come to with the research they had looked at. And that, coupled with the research in this country, the decline of pollinators, led me to the conclusion that we can do better, and we can start dialing back the access of those who aren't quite skilled in application, aren't educated to the level of those that have applicators license, but still allow them to be used in specific areas that are needed, such as bed bugs, so on and so forth. So with that, I ask again for an aye vote on Senate Bill 266.
Seeing no further discussion, the question before us is the adoption of Senate Bill 266. All those in favor signify by saying aye.
Aye.
Opposed? The ayes have it. That bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move Senate Bill 276 lay over to the end of the calendar.
The motion is to lay over 276 to the end of the calendar. All those in favor say aye. Opposed, no. Ayes have it. That will lay over. Will the clerk please read the title of Senate Bill 265?
Senate Bill 265 by Senator Van Winkle and Representative Snyder concerning a prohibition on a regulator imposing discipline against a person based on certain activities involving marijuana.
Senator Van Winkle.
Thank you, Mr. Chair. I move Senate Bill 265.
Is there any discussion? Oh, there's an amendment at the desk. Will the clerk please read L001?
Amendment L001 by
Senator Van Winkle.
Thank you, Mr. Chairman. This removes the applicability clause found on lines 19 and 20 on page 3. Typically, this is used for new crimes or increased penalties to give the public more time to prepare, to let them know when it's going to take effect. Since this bill is increasing permissibility, it does the opposite direction. It is not necessary in this bill whatsoever, so I ask for a yes vote on L001.
Seeing no further discussion, the question before us is the adoption of L001. All those in favor say aye. Opposed, no. Ayes have it. That amendment is adopted. To the bill, is there any discussion? Senator Van Winkle.
Thank you, Mr. Chairman. I renew my request for the passage of this bill in a yes vote. No one who lawfully consumes or possesses marijuana pursuant to Colorado law should be subject to professional sanctions or denied a professional license in the state of Colorado. I ask for a yes vote.
Seeing no. Senator Sullivan.
Thank you, Mr. Chairman. I am on the Business and Labor Committee, and we heard this bill in our committee yesterday, and I was still feeling the high from having the opportunity to speak about casino gambling, that it kind of caught me off guard, and it wasn't until later on that I really realized that this was actually a labor bill. It was actually a labor bill that we were discussing in Business and Labor. And I wouldn't have thought about that right off the bat when I would see that it was the senator from Highlands Ranch who was running this bill. So I had to reread it several times last night to double check and make sure that this senator was in fact standing up for the workers here in the state of Colorado, and especially those who had gotten themselves licensed, certified, and registered in a profession. And because I stand up for those people, especially through our apprenticeship programs and that. So just a couple of questions for the sponsor before we move on and get this passed. I just wanted to double check, is that in fact what you're doing, is standing up for labor here in the state of Colorado? Secondly, on these licensing and certified, are these only non-union licenses, or would these also be union workers? Would you be standing up for the union workers who got these licenses and these problems? Because I can recall last year we had a vote in which we seemed to indicate, or you indicated, and in one of the amendments, that people who joined a union were using their union dues to circumvent racketeering charges, that they were members of organized crime. So I'd also like to find out, are you standing with those members of the unions that are sending their money into organized crime units? Other than that, I think I'm with this bill and appreciate you bringing that forward.
Seeing no further discussion, the question before us is the adoption of Senate Bill 265. All those in favor say aye. Aye. Opposed, no. Ayes have it. That bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I request the Senate 205.
Granted.
How much did you learn about neonates there?
Fist bumps.
Thank you for allowing me. These are the finest traps. These are the finest traps I've ever seen. Thank you for allowing me to be under the massage trap. The trapeze is massive stuff. All right. It's getting a little weird up in here. Yeah. It's like someone said that I could. Next thing you know, no blame.
You have to promise.
James is generally a good guy.
Wife beaters, you know, the last time.
We are on that topic now.
When I first started wearing dress shirts like this, like in high school, my nipples were always raw. It's because I wasn't wearing undershirt. I wasn't wearing undershirt.
We are going there. It's getting weirder. It is getting weirder.
There was too much starch. There was too much starch in my shirt or something.
Look, I can't get in trouble if I don't respond or participate, right? Like, as long as I...
We are not getting into it. No, because of females here, you can't get into it.
Oh, that's a rule. I didn't know that. I thought you could. That's always the rule. So we can talk about... You just walk over to them.
No, but if you see me walk away, then you know you've gone too far.
Oh, okay. That's okay.
Does your wife walk away from you? That's what I want.
Oh my God. We have this
Is power? No, they're bringing,
No, it's the
they're bringing up Dylan's bill. I think it's like 24, which is going to cause some debate.
Yes, but
I think it's like...
I think only 35 minutes.
I think it's like they want it. And the election is not happening tonight, or the election is happening tonight?
Okay, I don't know about that.
And is power, power is at the end, is what the message, they're going to come back to power at the end.
Yes, that's right. That's what he says.
And how close did we get on that?
How close?
We've only done like 3 or 4 weeks.
Right.
Yeah, but I mean, how close did we get on power? Are we all finished?
I think it's negotiated, just not forever.
She came over and said something about an amendment.
There is an amendment. Yeah, I think she's trying to something.
Tom, I really appreciate you going down there and throwing family fun advice about
You seen go to the desk as soon as you start talking? He always does that.
Here's another way to rub salt into it. Start talking about what I'm saying. Is this rated on that website?
He loves the Liberty Scorecard.
They still have it. It's called Used to Be Principles of Liberty.
They still have
Get that
it.
email?
Yes, I get it. I get it.
It's called Liberty Scorecard now?
You don't get it.
I think you're actually one of the highest scoring DIMs. Probably. I don't know. I don't
Forward it to me. I'm not on the
I
list
get it. I
anymore.
don't open it.
Forward it to
Read
me.
it. Do you open it?
I just look at it, the grade they like
Yeah.
gave you, they grade A, B, C, D, F, and then,
I've probably always been. I don't know.
yeah, we're all in the 20s. Yeah. But like even like their highest one, like Stephanie Luck. I think you're in the 20s too.
Yeah, 20s. I don't open
Yeah,
it.
Stephanie
Do you
Luck
get
is
it?
her highest, and she's only in the 80s or like low 90s.
You don't open it either.
For ours?
Yeah, their highest is like 91.
curbing bad government. It was like a little cleanup bill. It didn't do anything, but like, he was like, no. I'm like, why would you know? And I look at it, I'm like, he voted against the cleanup bill. He's like, keep government screwed up. And that's conservative. I was like, what? Crazy.
Well, it makes your voting easy. You don't have to read
I
the
know.
bills. Just
Well, I
vote
think that's
no
why
on
he voted
everything.
no, is he didn't know what they did.
Yeah.
Otherwise, he just vote no and not over.
There's the cigar. I told you about the time we went there at the Orleans, and you're not a cigar smoker. Me and my buddy Dan are in the Orleans. We're sitting in the sports bar. We're smoking our cigars. They always, there's a couple of things that instantly you'll strike up conversations. You wear a Mets hat. Okay. Someone's gonna come by and be talking to you about it. Or you're smoking cigars. And they want to come over. Where'd you get it? What kind is that? Did you buy this here in town? Do you have it? I've got a box of Cubans in my car. Would you like to come out? I'll sell it to you. Oh yeah. Yeah. I'm not going to your car.
Yeah, you're
but,
gonna get your movie doing that shit.
So we're sitting there smoking. So the dude who's the sports book writer, he comes walking on over. He says, man, I couldn't help but notice you guys having a good time over here with your cigars. What are you smoking? Where'd you get them? In a brick house. We said, this one we got. So he says, have you heard of this place called Cigar Bins? I said, no. He says, it's an online place. He says, right. And so he says, I'm going on my break right now. He says, I'm gonna be checking my bags and stuff. He said, are you guys gonna be here tomorrow? I said, I'll bring you in. He said, take a look at this website. He says, once you start to get your point, so he said, I'll check in tomorrow if you guys are here. So we're there, and dude comes in, lays 6 cigars on us. These are different ones. We'll try them.
Your conversation is live on Colorado.
Well, that's okay.
We're just talking cigars. Okay, so you were talking cigars. I was told you were talking cigars. Yeah, so this whole conversation is being broadcast. Don't. Did they catch that? Please don't.
On which bill?
We weren't. You're live right now.
Yeah, yeah. Perfect.
So, 75% off. Your buddy?
Will the clerk please read the title to Senate Bill 276?
Senate Bill 276, Senator Fenberg, concerning modification to laws regarding elections.
Senator Fenberg.
Thank you, Mr. Chair. I move Senate Bill 276 along with the State Veterans Military Affairs Committee report.
And the Appropriations Committee
And
report?
the Appropriations Committee report.
To the SVA report.
Thank you, Mr. Chair. In the State Veterans Military Affairs Committee, we adopted 3 amendments, and it provided some clarification around the prohibition of state dollars. It fixed an error around presidential primaries and the issuance of allowing voters to prefer one ballot from just one party rather than getting both ballots. And then a miscellaneous amendment that sort of did various things, but largely fixed some technical errors and added a couple of words for clarification.
Seeing no further discussion, the question before us is the adoption of the SVMA report. All those in favor say aye. Aye. Opposed, no. Ayes have it. That report is adopted. To the Appropriations Committee report. Seeing no discussion, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye. Aye. Opposed, no. Ayes have it. That report is adopted. To the bill, Senator Fenberg.
Thank you, Mr. Chair. Members, Senate Bill 276 is a bill that further refines and improves our election system in Colorado. It makes various technical changes and cleans up errors that have needed to be cleaned up. It replaces some obsolete language, but it also does various things that are substantive. It improves our financial disclosure process for elected officials and candidates. It changes the reimbursement structure for counties around how they pay for conducting their elections. It does various things around where voter service and polling centers can be and what can occur there. It also provides various improvements to making sure that sort of the practice of what happens when it comes to running our elections at the county level are reflected in law rather than just simply being in practice or in election rule. So I think we're going to get into various aspects of the bill through amendments, so I'll leave the introductory remarks there and we can get into the amending areas and discuss other parts of the bill in detail.
Is there any further discussion? I'm assuming there is. Oh, there's an amendment coming to the desk. There's an amendment at the desk. Will the clerk please read L019?
Amendment L019 by Senator Fenberg.
Thank you, Mr. Chair. I move L19.
To the amendment.
Thank you, Mr. Chair. L19 fixes some aspects that were causing some concern around the personal financial disclosure aspect of the bill. It clarifies what is and what is not a source of income that needs to be reported and how it needs to be reported, and removes some of the penalties that were previously in the bill around whether someone can be disqualified if they file an inaccurate form. And I thought these were appropriate and don't harm the bill, and I think they are generally a good idea, so I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the adoption of L019. All those in favor say aye. Opposed, no. Ayes have it. That is adopted. There is an amendment on its way to the desk. Will the clerk please read L011?
Amendment L011.
Senator Fenberg.
Thank you, Mr. Chair. I move L11.
To the amendment.
Thank you, Mr. Chair. Okay, so this addresses an important part of the bill, but it makes some minor amendments. There's a part of the bill that several years ago we passed a law, and we have a practice in Colorado that we refer to as automatic voter registration. which essentially allows counties to update people's voter registrations when they interact with the government, like they get a driver's license. This allows our tribes here in Colorado to participate in that process if their tribal council opts into it and wants to do it for their members. There's a standard postcard that goes out to voters after they have registered, and it makes some clarifying updates to the language that postcard needs to be in. And then it also adds some clarifying language to how a sheriff's office or a county jail has to administer or facilitate voting or voter registration for people who are confined in their jail.
Is there any further discussion? Seeing none, the question before us is the adoption of L011. All those in favor say aye. Opposed, no. The ayes have it. That amendment is adopted. There is an amendment at the desk. Will the clerk please read L015?
Amendment L015.
Senator Fenberg.
Thank you, Mr. Chair. I move L15.
To the amendment.
Thank you, Mr. Chair. This is an amendment that was worked on with the County Clerks Association, and it provides some updated clarification for a few things. So there is a prohibition on using a cell phone if you are an election watcher and you're within view of personally identifiable information and things like that. And then there's also a similar clarifying language in the bill around a voter using a cell phone. For instance, if they want to text their mom while they're in the voting booth and be like, what was that candidate's name? Or what did I say I was going to vote on for this issue? Or they want to look up a voter guide or something like that. This bill provides some guardrails on what they can and cannot do with a cell phone in the election space. But we do say that if they want to make a call to a voter protection hotline or something, that would be okay. But the more important part of the bill is, or of this amendment, is that it's amending the part of the bill around if there's a very close election. And what happens after a very close election is a lot of voters didn't get their ballot counted because their signature didn't match, or they forgot to sign their ballot, or they didn't provide adequate ID. And they get a cure letter, essentially a letter saying that you need to go to your county clerk's office or go online or do something to make sure your ballot counts. Normally that just happens without a hitch and it's not a big deal. It's a very close election. A lot of people bother those voters to get them to fill out their cure postcard. The problem is that voter information isn't updated that quick sometimes, and so you will have a poor soul that could be a very important vote for the outcome of that very close election, and they get called or knocked on their door like a million times by both sides of the campaigns. This is to clarify when the county clerk has to update that information in the voter file every 24 hours so that that person gets taken off of people's lists sooner and they don't get bothered as much.
Is there any further discussion? Seeing none, the question before us is the adoption of L015. All those in favor say aye. Opposed, no. Ayes have it. That amendment is adopted. There is an amendment at the desk. Will the clerk please read L20?
Amendment L020.
Senator Fenberg.
Thank you, Mr. Chair. I move L20.
To the amendment.
This simply moves out the effective date for when the change in reimbursements occur and provides more time for the Joint Budget Committee, for the Secretary of State's office, to better figure out how we are going to pay for this increased reimbursement, if there is a cost share between the general fund, the cash fund, and if there is an impact on the cash fund, provides more of a ramp or a timeline to potentially think about increasing fees or building up that cash fund.
The Joint Budget Committee thanks you. Is there any further discussion of L020? Well, Senator Kirkmeyer.
Thank you, Mr. Chairman. The Joint Budget Committee doesn't thank you. We had this figured out at the Joint Budget Committee, so I'm sure the Secretary of State, though, is probably thanking you at this point. But I still look forward to seeing her budget next year.
As do I. Any further discussion of L020? Seeing none, the question before us is the adoption of L020. All those in favor say aye. Opposed, no. Ayes have it. That amendment is adopted. There is an amendment at the desk. Will the clerk please read L023?
Amendment 023 by
Senator
Senator
Fenberg.
Fenberg.
Thank you, Mr. Chair. I move L23.
To the amendment.
This is a strange amendment because this amendment strikes from the bill language and statute that the bill strikes. You following me? This basically removes the striking of obsolete language that we talked with the county clerk, Secretary of State's office, various folks, and decided that these are things that they have no force of law right now anyways. There are some that are small, little updates, but we are removing them from the bill. Some of them are obsolete because they only apply during times of COVID, but it takes up literally like a third of the bill. But there's going to be probably another cleanup bill next year, just like there often is, and we figured it made more sense to provide people more time and have a more comprehensive process and do that early next year rather than spending 30 pages in a bill at the very end of session striking obsolete language that arguably doesn't have any effective law anyways.
To keep the obsolete language, any further discussion? Seeing none, the question before us is the adoption of L023. All those in favor say aye. Opposed, no. The aye has it. That amendment is adopted. Will the clerk please read L017?
Amendment L017
Senator
by
Kirkmeyer.
Thank you, Mr. Chair. I move L017.
To the amendment.
Thank you, Mr. Chair. The bill right now lowers the legal standard to negligent. This just restores it back to the current standard of knowingly. Urge and I vote.
Is there any further discussion? Senator Fenberg.
Thank you, Mr. Chair. This was something that I felt was important, but I think it does warrant more conversation. And so I'm comfortable with accepting this as a friendly amendment and making sure that we have another conversation about exactly what the standard should be for these entities.
Seeing no further discussion, the question before us is the adoption of L017. All those in favor say aye. Opposed, no. Ayes have it. That amendment is adopted. Senator Gardner. There is an amendment at the desk. Will the clerk please read L18?
Amendment
Senator
L018.
Gardner.
Thank you, Mr. Chair. I move L018.
To the amendment.
Thank you. Members, those of you who follow your email closely may have gotten a notice of rulemaking from the Secretary of State advising you of a rule change with respect to the Secretary's hiring of administrative law judges directly by the office rather than using the Office of Administrative Courts. Now, this is important. It's important because campaign finance complaints and other matters are made to the Secretary of State, and then the office is required by law to refer the matter for hearing to an administrative law judge. Now, until recently, by agreement with the Department of Personnel and Administration, where the Office of Administrative Courts is, and a branch that is independent of the Secretary of State, administrative law judges there heard campaign finance complaints. Without getting into the reason that there was a conflict between the Office of Administrative Court and the Secretary of State's office, they no longer have an agreement to do that. And the Secretary has announced in the rulemaking that she will be hiring the administrative law judges. Now, that gives me concern because these campaign finance complaints are by their very nature partisan and should be heard by a neutral judge, someone that is not beholden to their job, for their job with the Secretary of State. Those of you who follow the jurisprudence of the United States Supreme Court will know that there are some recent cases involving separation of powers and due process in which the United States Supreme Court has called into question the Securities and Exchange Commission's use of their own internal administrative law judges, not independent administrative judges. And this is the same problem. It is the same problem, and L018 proposes a solution to the problem by creating a board that would choose the administrative law judges, that the board would be made up of people that were not as a whole dominated by one party or the other, and that they would get a list of employees. That list of employees would, or that list of prospects or applicants would be vetted, and a panel of 3 of them would be referred to the Secretary of State, who would, in essence, be, under the amendment, obligated to hire these 3 people, and thus they would not be beholden to the Secretary for their job, but would rather function independently of the Secretary of State. This is only necessary because of this conflict, and there needs to be an independent way to choose these hearing officers, administrative law judges. I don't fault the Secretary for publishing rules and trying to figure out how are they going to do their hearings, because they need to be able to do the hearings. But the interesting thing is that the conflict that has arisen because there was a disagreement between the Office of Administrative Courts and a decision there and what the Secretary of State thought the decision ought to be and disagreed with it, highlighting the fact that we need this amendment. So I ask for an aye vote on L018.
Is there any further discussion of L018? Senator Fenberg.
Thank you, Mr. Chair. This is a very important issue, and I'm sure you are all listening to the senator from Colorado Springs, and you understand it, and you know exactly what it's about. But, and we talked about this, and this is something that's new, that recently occurred around ALJs and the OAC and the SOS and all these other abbreviations. I think there's something here. I think it's a conversation we should have. I don't think this is the time to do it. Emergency rules were just issued. And this is something that I think we can fix or address or somehow work on for January, for next session. I don't think this is urgent, and I think it warrants more stakeholder conversations to make sure we're not doing anything wrong or breaking something in the process. So I ask for a no vote.
Is there any further discussion of L018? Seeing none, the question before us is the adoption of L018. All those in favor say aye. Aye. All those opposed, no. No. The noes have it, and that amendment is lost. Senator Pelton. There is an amendment at the desk. Will the clerk please read L009?
Amendment L009 by Senator Pelton
Senator
B.
Pelton.
Thank you, Mr. Chair. I move L009.
To the amendment.
What this amendment does is that it removes the changes to the numbers of the students on the higher ed campuses. And the reason why I'm bringing this to you, members, is that when we lowered the numbers to, what was it? When we lowered the numbers, we just added a lot of junior colleges in this. And I'm not saying that junior college shouldn't be able to vote. I'm just saying that in my district with the county clerks, it's going to be really hard to man that box and to be able to put the cameras on and all that other stuff for the boxes. So that's why I'm asking for this, is because of the junior colleges or the community colleges in our small rural communities and the cost it's going to add to them on the budget. So I ask for an aye vote.
Is there any further discussion? Senator Fenberg.
Thank you, Mr. Chair. I am going to ask for a no vote on this. This is, we actually did tweak this. This is around the campuses. We did tweak this in one of the amendments we just passed, actually. And in conversations with the county clerks, we generally changed the threshold back to what it was for drop boxes. So we're not touching that, but it does still, the threshold does still change for campuses. However, it only applies to 4 campuses in the state, the threshold change. And my understanding is that those campuses want those VSPCs, and the county clerks in those counties are okay with that and are going to be pursuing it. So they are fine with the changes that were made in our amendment, and I think everyone is happy. So that's why I'm asking for a no vote, because I don't think this is needed and it goes farther than what was agreed upon.
Is there any further discussion? Seeing none, the question before us is the adoption of L009. All those in favor say aye. Aye. Opposed, no. No. Noes have it, and that amendment is lost. There's an amendment at the desk. Will the clerk please read L008?
Amendment L008 by
Senator
Senator.
Belton.
Thank you, Mr. Chair. I move L008.
To the amendment.
What the amendment does is it changes the number of VSPCs in a county. The reason why I'm bringing this amendment, this comes from my county clerk, and I talked to the president about this several times, and we can work on it further, but I just want to make sure that in my county, in the city of Sterling, we have 3 VSPs that I can walk to, all 3 of them. One of them includes the courthouse. I can walk to all 3 of them in the lunch hour that I used to take when I was the county commissioner. That's how close they are. Our largest municipality is Sterling, Colorado. When you have that large municipality, all the VSPCs will be in that municipality. And from a budget perspective, especially when you're a county commissioner, this is almost just a waste of money because nobody uses one of those VSPCs every year. So it's close to the tune of $27,000. So I ask for an aye vote.
Senator Fenberg.
Thank you, Mr. Chair. I'm going to ask for a no vote on this. I think there is a concern here. I think there's something here. I think there's validity to it. I've had conversations with the Logan County clerk about this and some others. I think there's a conversation to be had, but I do want to remind folks that we're talking about a voter service center just on election day. So this isn't for the whole period, it's just one day. And the number that I was given for that particular voter center in Logan County is about, I think, $27,000. It's a lot of money if no one's using it, I suppose, but also we are, through the reimbursement changes, we are more than adequately paying for that from an additional investment from the state. Every county is different. It's hard to write these formulas for it to make perfect sense for every county based on population. But the reason why I'm definitely not supportive of moving in this direction right now is because it would include some counties that have the same population size as Logan that don't have this 3 population center threshold, but might have a mountain pass in their district or in their county. And so it's important to make sure that there is still a variety of voter service centers, because even though it's a small county, it might take a very long time for someone to drive over to that voter center on election day to get the services they need. And so for now, I'm asking for a no vote. I think this is something that we could bring back up in next session. And if we address it, there won't be an election between now and then that this would apply for. So it would make no difference if we address it today versus January or February next year. So I'd like to have a further conversation, make sure we're not doing harm to some of these, especially Western Slope districts or counties, where a voter could be left without a voter center that's accessible to them on election day if we move forward in this direction. So I ask for a no vote.
Senator Pelton.
Thank you, Mr. Chair. And in my former House district, I had Logan County, and so I appreciate this amendment. I haven't really had any of my clerks reach out, but I do believe I probably have some cities that would fit maybe in this same threshold. So I really would urge support for this amendment.
Is there any further discussion? Seeing none, the question before us is the adoption of L008. All those in favor say aye. Opposed, no. Noes have it. That amendment is lost. Is there any further discussion of Senate Bill 276? Seeing none, the question before us is the adoption of Senate Bill 276. All those in favor say aye. Opposed, no. Ayes have it. That bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
The motion is for the committee to rise and report. All those in favor say aye. Aye. Opposed, no. Ayes have it. The committee will rise and report.
The Senate will come back to order. Senator Bridges.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Will the clerk please read the report?
Mr. President, your committee of the whole begs leave to report that it has had under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. Senate Bill 266 is amended, Senate Bill 265 is amended, Senate Bill 276 is amended, passed on second reading, and ordered, engrossed, and placed on the calendar for third reading and final passage.
Senator Bridges.
Thank you, Mr. President. I move the report.
The motion is the adoption of the committee of the whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, the committee of the whole report is adopted. Senate Bill 266 is amended, Senate Bill 265 is amended, Senate Bill 276 is amended, passed on second reading, order engrossed, and placed on the calendar for third reading and final passage. General orders, second reading of bills. Senator Bridges.
Thank you, Mr. President. I move that the Senate resolve itself into the committee of the whole for the consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. Aye. The aye. No one's opposed to this.
Come on, it's going to be great.
Opposed, no?
I'm in the chair.
Just one. The ayes have it. The motion is adopted. The Senate will resolve itself into the committee of the whole for the consideration of the general orders, second reading of bills, and Senator Bridges will take the chair.
The committee will come to order, and the code rule is relaxed for everybody. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee proceed out of order for the consideration of Senate Bill 172.
The motion is to proceed out of order for the consideration of Senate Bill 172. All those in favor say aye. Opposed, no. Ayes have it, and we will do so. The clerk please read the title, Senate Bill 172.
Senate Bill 162 by Senator Winter F. and Gonzalez, Representatives Weissman and Bacon, concerning protections for Colorado workers against discriminatory employment practices.
I believe that we were on 172. Did I say 162? Will the clerk please read the title to 172?
Senate Bill 172, Senator Winter F. and Gonzalez, Representatives Wiseman and Bacon, concerning protections for Colorado workers against discriminatory employment practices.
We might do 162. Senator Gonzalez.
Thank you, Mr. Chair. I move Senate Bill 172 on second reading and ask for an aye vote.
Mr. Minority Leader.
Thank you very much, Mr. Chair. Appreciate the motion to move 172, which gives us, of course, under the rules of the Senate or the Committee of the Whole, as we are at this moment, the opportunity to discuss the matter before us. We were having conversations previously. There was a ray of hope, a moment of sunshiny brightness where we thought we might be able to make a small change in this act and get a significant portion of the business community to a place where we could say, this isn't such a bad bill after all. And we're still considering that. So I guess that falls upon me then to explain the finer points of this bill until we come to an agreement. And since my voice grates on most people's nerves, I think we'll come to agreement quickly on where. Oh, Gardner's voice grates on people's nerves more than mine?
We're getting awfully close to disparaging members of the.
Fair enough. Fair enough. I know I am a competitive individual. When somebody throws down a competition, I seek to win the competition. Most grating voice was the competition I was trying to win at that moment. Back to the bill and to seriousness. The matter at hand, the matter under discussion, the matter that is important really intersects with who Colorado is in the eyes of employers and the experience of employees. The Power Act seeks to do some important things about how we choose to interact with each other as human beings, treat each other with respect, the sorts of things that I think we do a pretty good job of here in this chamber, and we could always improve. There's no question about that. Of course, we write laws, and so this law seeks to, by virtue of putting black letters on white pages and red books, change the way people behave. But of course, that's not the way it ever works. The particular matter at hand that is being discussed has to do with the idea of an affirmative defense that's built into the bill for employers. If employers are doing the sorts of things that demonstrate they are good faith actors, if they are in fact seeking to establish best practices, best behaviors, and seeking to avoid the sort of intrusive, disrespectful interactions between human beings that none of us want to see happen, that then they are, in the course of any prosecution, provided with some sort of an affirmative defense. I think I might want to move an amendment. Yeah, let's take a senatorial 5. I think that's the smart thing.
Senatorial 5.
Senator Gonzalez.
Thank you, Mr. Chair. Renew my motion to pass Senate Bill 172 on second reading and ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the adoption of Senate Bill 172. All those in favor say aye. Aye. Opposed, no. Ayes have it. That bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move to lay over the balance of the calendar until tomorrow, April 20th.
The motion is to lay over the balance of the calendar until tomorrow. All those in favor say aye. Aye. Opposed, no. Ayes have it. We will lay over that calendar. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
The motion is to rise and report. All those in favor say aye. Opposed, no. Ayes overwhelmingly have that one. We will rise and report. Did I leave something up there? I'm a mess. That's, yeah.
Senate will come to order. Senator Bridges.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Will the clerk please read the report?
Mr. President, your committee of the whole begs leave to report it has had under consideration the following attached bills being the second reading thereof and makes the following recommendations on Senate Bill 172 as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1190, House Bill 1224, Senate Bill 200 laid over until April 20, 2023 and retaining their place on the calendar.
Senator Bridges.
Thank you, Mr. President. I move the report.
Motion is for the adoption of the committee of the whole report. Are there any no votes? With a vote of 34 ayes, 0 no, 0 absent, 1 excused, committee of the whole report is adopted. Senate Bill 172 is amended, passed on second reading, order engrossed, and placed on the calendar for third reading and final passage. House Bills 1190 and 1224 and Senate Bill 200 laid over until April 20th and retaining their place on the calendar. Committee reports.
April 19, 2023, Mr. President, the Committee on Education has had under consideration and has had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar confirmed. Members of the Private Occupational School Board for terms expiring July 1st, 2026, Scott Cardona of Denver, Colorado, to serve as a representative of the general public who is an owner or operator of business within Colorado that employs students who are enrolled in schools that are subject to administration by the Private Occupational School Division. Appointed Jessica Shea, who's of Federal Heights, Colorado, to serve as a representative of the general public who's an owner or operator of a business within Colorado that employs students who are enrolled in schools that are subject to administration by the Private Occupational School Division. Reappointed Ellen Mary Wamser of Lakewood, Colorado, to serve as a representative of the general public and who is employed by a lending institution located in Colorado and is familiar with the Colorado College Access Network. Reappointed April 19, 2023, the Committee on Education. After consideration on the merits, the committee recommends the following Senate Bill 287 be amended as follows, and as so amended, be referred to the Committee on Appropriations with favorable recommendation.
Delivery to the governor.
April 19, 2023, to the governor for signature on Wednesday, April 19, 2023 at 1:15 p.m. Senate Bills 83, 219, 228, and 229.
Announcements. Senator Coleman.
Thank you, Mr. President. Members, just really quickly, there's been a change in the order for State Veteran Military Affairs Committee, and I wanted to make sure I made the announcement so folks were aware of it tonight in preparation for tomorrow. We will be hearing bills in this order: House Bill 1206, Senate Bill 286, and then Senate Bill 279 in that order. Thank you very much, Mr. President.
Senator Gardner.
Thank you, Mr. President. Committee on Legal Services, looking at all of you, I regret to inform you that we still have an 8 a.m. meeting to hear the ever-important rule review bill. See you there. I don't know what room it is. Check your calendar, but 8 a.m. Sorry about that.
Further announcements. Majority Leader Moreno.
Thank you, Mr. President. Colleagues, a couple of quick announcements. One, please take your file folders off of your file cabinet so that our assignables can go home. One other quick announcement on future filing policy. From now on, assignables will unfortunately not be able to pull the bills on the calendar that day. You'll have to have your legislative aide do that for you. They will still file the bills for you, but in order to just manage the workload a little bit, they will not be pulling bills for you on the calendar that day. So please ask your legislative aide to do that for you if you need that to happen. And lastly, we will be having a late start of 10 a.m. tomorrow. So with that, Mr. President, seeing no further announcements, I move that the Senate adjourn until tomorrow, Thursday, April 20th at 10 a.m.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it, and the Senate will adjourn until tomorrow, 10 a.m., April 20th.